advocates, the registrars, the Director Judicial Academy, the Secretary Telangana State Legal Services Authority, the law officers and other officers, respected senior members of the bar and junior advocates, Madam Sangamitra Bhuyan, Mrs. Sweta, and friends and family members of Honorable Chief Justice Sri UJJAL BHUYAN, ladies and gentlemen. We have gathered here today with mixed feelings, like it is often said, all good things must come to an end. Today, the time of our High Court under the helm of our Lordship Sri Justice UJJAL BHUYAN has seen its last day. But this good thing has made way to a great beginning, as my lords will soon take oath as Judge of the Honourable Supreme Court. His Lordship was born on 2nd August 1964 at Guwahati to Sri Suchendranath Bhuyan, a senior advocate and former Advocate General of Assam, and Srimati Subhadra Bhuyan. His Lordship did his schooling in Don Bosco High School, Guwahati, and thereafter studied in Cotton College, Guwahati. After graduating in arts from Kirori Mal College, Delhi, His Lordship graduated with LLB from Government Law College, Guwahati, and did his masters in law from Guwahati University. His Lordship enrolled as an advocate on 20th March 1991 with the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. His Lordships had been a member of Guwahati High Court Bar Association, Lawyers Association Guwahati, Bar Association of India, All India Federation of Tax Practitioners, and Indian Law Institute, Assam Chapter. His Lordships practiced before the principal seat of Guwahati High Court at Guwahati and appeared before the Agartala, Shillong, Kohima, and Itanagar benches of Guwahati High Court, and including before fora such as Central Administrative Tribunal, Guwahati Bench, the Assam Board of Revenue, Labour Court, Guwahati, various civil courts, and the State Consumer Forum, Arunachal Pradesh. His Lordship was the Standing Counsel of the Income Tax Department for 16 years, starting as Junior Standing Counsel in May 1995, and subsequently appointed as Senior Standing Counsel of the Income Tax Department in December 2008. His Lordship was the Additional Government Advocate Meghalaya in the principal seat of the Guwahati High Court from April 2002 to October 2006, and was engaged as Special Counsel of the Forest Department, Government of Arunachal Pradesh from December 2005 to April 2009. His Lordship was appointed as Standing Counsel of Guwahati High Court in March 2010 and designated as Senior Advocate by the Guwahati High Court in September 2010. His Lordship was thereafter appointed as Additional Advocate General of Assam in 2011. A call to the bench came in 2011 and His Lordship was appointed as Additional Judge of Guwahati High Court on 17th October 2011 and as a Permanent Judge of Guwahati High Court on 20th March 2013. His Lordship was also the Executive Chairman of Mizoram State Legal Services Authority and was closely associated with the Judicial Academy Assam and National Law University Guwahati. His Lordship was transferred to Bombay High Court in 2019. After a 2-year tenure at Bombay High Court, His Lordship was transferred to our High Court and took oath as Judge of this court on 22nd October 2021. His Lordship was sworn in as Chief Justice of our High Court and assumed charge on 28th June 2022. During my Lord's tenure as the Chief Justice of this court, my Lords conducted the court proceedings in the most meticulous and organized manner. The discipline my Lord has inculcated in the members of the bar during the court proceedings will stand out as an extraordinary example. Upon my Lord's initiative, the court proceedings of the first court have been streamlining, live opening the doors of this temple of justice to the public in a way it was never done before. His Lordship also made the proceedings of the court to run on hybrid mode, making it convenient for many advocates to present their cases even when they cannot be physically present in the court, and thus allowing the cases to be heard on the day when they are listed, without any need to adjourn them. During the period from 22nd October 2021 to 13th July 2023, my lords, as judge of this honorable court, and thereafter as the Chief Justice of this honorable court, disposed of 4,862 main cases, out of which 4 cases are full bench cases, 4,487 are division bench cases, 371 cases are single bench cases. His Lordship disposed of 2,969 writ petitions, 88 PALs, 886 writ appeals, 187 ITTA cases, apart from 6,214 miscellaneous cases disposed of by His Lordships. The workaholic nature of His Lordship personally is reflected in the number of working days which His Lordship attended court. Out of 360 court working days, His Lordship conducted court proceedings on 348 days. During my interaction with my lords, it was perceptible that my lords had the welfare of the legal fraternity on a very high priority. To this effect, it was my lord's initiative to have a highly equipped ambulance in the precincts of our High Court. A judge with pleasing personality, my lords ensured that the needy are not left behind in the assertion of their constitutional rights. Can pay compensation of rupees 10 lakhs each to their dependents and make all efforts to rehabilitate the families of such manual scavengers. During his lordship's tenure as judge of the high courts, my lords has rendered numerous judgments on diverse subjects of the law. This farewell would be incomplete without reference to some of the landmark judgments which reflect my lord's in-depth knowledge and understanding of the law and his lordship's versatility. In V. Vasanta Mogili versus State of Telangana and others, WPPAL 74 of 2020 and batch, 3 public interest litigations filed to declare Telangana Eunuchs Act 1329 firstly as ultra-virus and unconstitutional. Mandates maintenance of a register of eunuchs residing in the city of Hyderabad who are suspected of kidnapping or emasculating boys or of committing unnatural offences or abetting the same. The Act permits arrest of transgender persons without a warrant and punished with imprisonment if found in female clothing or ornamented or singing, dancing or participating in public entertainment in a street or a public place or where a transgender person is found in the company of boy below the age of 16 years. His Lordship, on a thorough examination of the provisions of the Act and a comparative analysis of the said Act with the Colonial Criminal Tribes Act 1871, found that the provisions of both the Acts are almost pari materia. His Lordships noted that the Criminal Tribes Act 1871 was repealed in 1952 and how the enactment was not only arbitrary but had stigmatized entire communities including the eunuchs as criminals. Once a tribe was declared as a criminal tribe or in case of eunuch they were presumed to be criminal and police had the power of surveillance over them to arrest them and to monitor their day-to-day lives. Following the law laid down by the Supreme Court, His Lordship held that there can be no iota of doubt that such enactment is anathema to our constitutional philosophy. His Lordships observed that the enactment is manifestly arbitrary as it criminalizes the entire community of eunuchs and it is violative of the human rights of the third gender community. Further, it is also an intrusion into their private sphere as well as an assault on their dignity. It is thus offensive of both the right to privacy and the right to dignity of transgender persons. So not only violative of Article 14 but also clearly violative of Article 21 of the Constitution of India. Such an enactment can no longer continue to find a place in our statute book, so accordingly declared it as unconstitutional. His Lordship also directed that Asara pension scheme shall be extended to the transgenders and that executive instructions may be issued by the state to provide reservation in educational institutions and public services, and that the State Welfare Board for Transgender Persons, Telangana State, shall co-opt member secretary Telangana State Legal Services Authority as one of its members. It shall be a permanent body through individual members may have a limited tenure, and State Welfare Board for Transgender Persons, Telangana State shall monitor the various steps taken by the Government of Telangana for upliftment of the transgender community, including the proper and effective implementation of the Transgender Persons Protection of Rights Act 2019 and the Transgender Persons Protection of Rights Rules 2020. In the National Highway Authority of India versus G. Narsingh Rao and others, a case where the action to acquire the land of certain persons for the purpose of four-laning of NH 161 for the stretch covering Sangareddy, Nanded, Akola was opposed. His Lordships, after referring to provisions of the National Highways Act 1956 and the steps taken thereunder for acquisition of land by the owners of the land, of filing objections to the notification issued under Section 3A, which were considered rejected, taking into consideration the plan submitted by the DPR expert by the appropriate authority. After which, even a notification under Section 3D was issued, observed that an issuance of declaration under Section 3D of the National Highways Act 1956, the subject land stood vested absolutely with the central government, free from all encumbrances. Since the National Highways Act 1956 lays down the procedure for acquisition of land for laying of national highways, including award of compensation, the owners of the land have their remedy thereunder, and since acquisition of land is for the purpose of four-laning of national highway, which is of public interest, interference by the High Court under Article 226 of the Constitution of India would not be justified, more so in the absence of any materials placed on record to prove that execution of four-laning NH 161 project is actuated by malafides to oust the writ petitioners from their land. In Sidra Mehboob Sheikh alias Sunita Raja Pramanik versus State of Maharashtra and another, His Lordships dealt with an issue where the petitioner filed seeking a direction and permission for medical termination of her pregnancy on the ground that the pregnancy is having an adverse impact on her mental health on account of continuing domestic violence. His Lordships interpreted the phrase mental health used in the Medical Termination of Pregnancy Act 1971 and observed that mental health is more than just the absence of mental disorders or illness. Mental health is a state of well-being in which an individual realizes his or her own potential, can cope with the normal stresses of life, can work productively and is able to contribute to his or her community. When we say that a person is in good mental health, it would mean that he is mentally equipoised or is at mental equilibrium. Thus, from the above analysis, we can safely say that the expression of mental health is a wider concept encompassing within its fold the expression mental illness. In that context, His Lordship held that the legislature has consciously used the expression mental health in Section 3(2)(b) one of the MTP Act in contradistinction to the expression mental illness or mentally ill person. His Lordship allowed the petition, concluding that it is undeniable that the petitioner is a victim of domestic abuse and that she has taken the necessary legal action as a result. She is also seeking a divorce from her husband. She has contended that if the kid is born, she will not have her husband's financial and emotional support, and without that support, it will be impossible for her to raise the child because she has no other way to make money. His Lordship came to a reasoned decision to grant the petitioner's request for an abortion, while observing that refusing to do so would amount to forcing her to carry the child, which under the given circumstances would not only be oppressive and burdensome for her, but also have the potential to seriously harm our mental health. In Messrs. Maruti Ginning and Pressing Factory and others versus the Recovery Officers Debt Recovery Tribunal 2 Hyderabad, a case where I had the privilege of assisting His Lordships as the amicus curiae. The issue arising in a batch of writ petition was whether a subject matter taken up by the Debts Recovery Tribunal 2 Hyderabad or any order passed by the said tribunal and a dispute arising out of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, more commonly known as SARFAESI Act, when both the parties to the dispute as well as the cause of action had arisen in the state of Andhra Pradesh. If the jurisdiction to deal with such writ petitions would be of High Court of Telangana or the High Court of Andhra Pradesh, His Lordships, after a thorough discussion on various judgments of the Supreme Court and various High Courts, held that, having regard to Section 17(1)(a) of the SARFAESI Act, since the cause of action arose in 4 districts of Andhra Pradesh, namely Anantapur, Chittoor, Kadapa and Kurnool, where the borrowers, secured assets and the secured creditors are located, as well as the loan transaction had taken place, it is the High Court for the state of Andhra Pradesh which will have the jurisdiction in matters arising out of SARFAESI Act in respect of the above 4 districts. In the event no securitization application is filed under Section 17 of SARFAESI Act, the position becomes very simple. The parties being within the state of Andhra Pradesh and the cause of action also arising within that state, the High Court for the state of Telangana at Hyderabad would have no territorial jurisdiction to entertain any writ petition relating thereto, even if a securitization application under Section 17 of the SARFAESI Act is filed before the Debt Recovery Tribunal 2 Hyderabad or any order is passed by the said tribunal on such application, then also the High Court for the state of Telangana at Hyderabad would not have the territorial jurisdiction to entertain any writ petition relating to such proceedings before the Debt Recovery Tribunal 2 Hyderabad, though the said tribunal is within the jurisdiction of this court. In Y. Lakshmana Rao versus Union of India, a writ petition filed by a scientist, the petitioner who was not promoted as a scientist, engineer contrary to law. His Lordship, while adjudicating the writ petition, expanded the scope of principles of natural justice, further by holding that the fairness and transparency in public administration requires that all entries in the annual confidential report of a public servant, whether in civil, judicial, police or any other state service except the military, must be communicated to him within a reasonable period so that he can make a representation for its upgradation. His Lordships held this to be correct legal position, even though there may be no rule GO requiring communication of the entry, or even if there is a rule GO prohibiting it, because the principle of non-arbitrariness in state action as envisaged by Article 14 of the Constitution requires such communication, and since Article 14 overrides all rules or governing orders, His Lordship, speaking for the bench, further held that when the entry is communicated to him, the public servant should have a right to make a representation against the entry to the authority concerned, and the authority concerned must decide the representation in a fair manner and within a reasonable period, and the representation must be decided by an authority higher than the one who gave the entries, since otherwise the likelihood is that the representation will be summarily rejected without adequate consideration, as it would be an appeal from Caesar to Caesar. His Lordships held that this would be conducive to fairness and transparency in public administration and would result in fairness to public servants, and that the state must be a model employer and must act fairly towards its employees. Only then would good governance be possible. Justice UJJAL BHUYAN is an epitome of patience, hard work and humanity. His Lordship's patience was palpable, whether it be while hearing the cases or during the dictation of the orders. His Lordship rise to the apex court is a result of untiring hard work. The humane approach and love towards the downtrodden have always been hallmark of His Lordship's personality. The junior members of the bar are elated at my Lord's elevation to the Honourable Apex Court and have shared with me the bonding they have developed with my Lords. They have also expressed how encouraging it was in appearing before my Lords. I am grateful to my Lords for the support and encouragement that has been bestowed on the next generations. It is truly a commendable gesture. We are glad and happy that my lords had been appointed as a judge of the Honourable Apex Court and would miss the presence of my lords in the first court. During the tenure here, my lords has proved to be a judge of highest caliber, simple demeanor and strict discipline. My lords has created a special place in the hearts of every member of legal fraternity of Telangana and are thankful for every endeavor that my lords has made for the betterment of the people of Telangana, and we wish a grand success during his lordship's tenure at the Honourable Supreme Court. Thank you. Minutes.
Honorable Chief Justice UJJAL BHUYAN, Chief Justice and Judge Designate, Honorable Supreme Court of India, my brother and sister judges, Sri Secretary Retired Learned Advocate General Sri Shivanand Prasad and his team, and Additional Advocate General Sri J. Ramchandra Rao, and the Public Prosecutor Sri Pratap Reddy, and the Chairman Telangana State Bar Council Sri Narasimha Reddy, and the Deputy Solicitor General Sri G. Praveen Kumar, Sri Palle Nageshwar Rao, President Telangana High Court Bar Association and his team, Srimati Sangamitra Das Bhuyan, wife of Honorable Chief Justice, Mrs. Sweta Bhuyan, daughter, friends of Honorable Chief Justice, Learned Senior Counsel, Registrar General and a team of registrars, Director Telangana State Judicial Academy, Secretary Telangana State Legal Service Authority, Learned Advocates, print and electronic media, and dear friends. Honorable Justice UJJAL BHUYAN was born on 2nd August 1964 at Guwahati. His father, Suchendranath Bhuyan, was a senior advocate, the former Advocate General of State of Assam. He obtained his LLB degree from Government Law College and Guwahati and LLM degree from Guwahati University, Guwahati. He was enrolled on 23/1991 with the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. I practiced before the principal seat of Guwahati High Court at Guwahati and appeared before the Agartala, Shillong, Kohima, and Itanagar benches of the Guwahati High Court. Also practiced before the Central Administrative Tribunal, Guwahati bench, the Assam Board of Revenue. Appeared before the Labour Court, Guwahati, various civil courts, and the State Consumer for Arunachal Pradesh. He was the Standing Counsel of the Income Tax Department for 16 long years. As a Senior Standing Counsel also with the Income Tax Department. He was the Additional Government Advocate Meghalaya in the principal seat of the Guwahati High Court from April 2002 to October 2006. He was engaged as Special Counsel of the Forest Department, Government of Arunachal Pradesh from December 2005 to April 2009. Appointed as Standing Counsel of Guwahati High Court on 3/3/2010. Designated as Senior Advocate by Guwahati High Court on 6/9/2010. He was appointed as Additional Advocate General Assam on 21/7/2011. A long list reflecting illustrious career. Honorable Chief Justice was a member of Guwahati High Court Bar Association, Lawyers Association Guwahati, Bar Association of India, All India Federation of Tax Practitioners, and Indian Law Institute Assam Chapter. Appointed as Additional Judge of Guwahati High Court on 17th October 2011 and confirmed on 28th March 2013. He was also the Executive Chairman of Mizoram State Legal Service Authority. Justice UJJAL BHUYAN was closely associated with the Judicial Academy Assam and National Law University Guwahati. Transferred to Bombay High Court and took oath as Judge of the Bombay High Court on 3/10/2019. After a 2-year stint at Mumbai, transferred to Telangana High Court and took oath as Judge of Telangana High Court on 22/10/2021. He was the Executive Chairman of Telangana State Legal Service Authority, sworn in as Chief Justice of High Court for the State of Telangana on 28/6/2022, appointed as Judge of the Honourable Supreme Court of India. That's how we have assembled today. Honourable Chief Justice is demitting the office of Chief Justice to take higher responsibilities as Judge of the Supreme Court. His tenure as a judge, as a senior most judge, and as Chief Justice shall stand as a watermark on several aspects. First, he has never availed a single day's leave in the entire tenure in Hyderabad. During his tenure as Chief Justice, His Lordship has initiated several measures for improving infrastructure facilities in the Judicial Academy and special attention is paid for imparting training to judicial officers and ministerial staff. He has taken classes to judicial officers and evinced keen interest in inculcating work culture to the trainees. During his tenure in this court, comprehensive mega medical camp was held for advocates, officers and staff of High Court from 27th to 29th July 2022. Here, Aadhaar card updation facility center was extended for 6 months. Under his leadership, massive recruitment drive was undertaken to fill the posts in the judicial service, the ministerial service of the district judiciary, and in the High Court service. During his lordship's assignment as executive chairman, Telangana State Legal Service Authority, with effect from 22/10/2021, the Telangana State Legal Service Authority has conducted 40 hours mediation training program for the advocates of Hon'ble High Court from 4th May 2022 to 8th May 2022 at Telangana State Judicial Academy. A two-day national conclave of members, secretaries of 23 state legal service authorities on incremental expansion of legal aid defense council system was organized by the Telangana State Legal Service Authority on 29/5/2022 and 30/5/2022 under his leadership. Under his leadership's vision and guidance, Telangana State Legal Service Authority has successfully conducted Pan-India Legal Awareness and Outreach Campaign in the state of Telangana from 2nd October 2021 to 14th November 2021 by organizing various activities as per the guidelines and timeline of NALSA. The then Executive Chairman, NALSA, has also launched the theme song titled Satvara Nyayam in Telugu language prepared by Telangana State Legal Service Authority under his guidance, which was widely uploaded all over the country. During his tenure as Patron-in-Chief on 2/1/2023, 23 newly constituted district legal service authorities are opened in the state of Telangana. District legal service authorities are constituted and are functional in all the judicial districts of the state of Telangana. Honorable Sri Justice UJJAL BHUYAN virtually inaugurated the Office of Legal Aid Defense Council in all the districts of the state, and they are now functional. Under the dynamic vision and guidance of His Lordship, the Telangana State Legal Service Authority, for the first time in the country, has devised a novel scheme called Agri Legal Aid Clinics, intended to educate the farmers of the state of agriculture laws and agriculture welfare schemes, and also to make them aware about their rights, responsibilities, and availability of legal remedies under the law. Under the guidance of His Lordship, the Telangana State Legal Service Authority has conducted a program on art of mediation and negotiation in alternative dispute resolution process, concept and techniques of mediation from 1/5/2023 to 3/5/2023 at Kana Shantivanam Mediation Center to all the honorable judges of the state of High Court for the state of Telangana. During his lordship's tenure as the then executive chairman, Telangana State Legal Service Authority has successfully conducted 3 national local adalats in the state. In these 3 national local adalats, a total number of 12,84,044 cases were settled and awarded compensation of 317.92 crores. During tenure as Patron-in-Chief of the Telangana State Legal Service Authority, successfully conducted 4 national local adalats, in which a total number of 12,19,639 cases were settled and an amount of rupees 529.43 crores was awarded as compensation. These are only few. The list of achievements on various aspects is very big. As we call it in Telugu, they are only a machu tunaka. My association with Honorable Justice UJJAL BHUYAN has been very cordial, and I shall cherish for years to come. To my misfortune, he will not be giving me farewell as we all thought. He is a very humble and amiable person, always smiling and friendly. When we interacted with him, we never thought that we were speaking to a Chief Justice. Even when he expressed displeasure on any issue, he used to convey the message in a sober manner. He is a good host, without fear of contradiction of my sister and brother judges. I can say that he has truly led us from the front. I, on my behalf and on behalf of my sister and brother judges, wish your lordship a very happy and satisfactory tenure as judge of the Honorable Supreme Court. I am sure in the next 6 years, we will be reading several landmark judgments rendered by your lordship in the Honorable Supreme Court. Thank you.
My friend and brother, Justice P. Navin Rao, and all my esteemed colleagues on the bench, Mr. B.S. Prasad, Learned Advocate General for the State of Telangana, Mr. J. Ramchandra Rao, Learned Additional Advocate General for the State of Telangana, Mr. A. Narasimha Reddy, Chairman, Bar Council of Telangana, Mr. Palle Nageshwar Rao, President, Telangana High Court Advocates Association, Mr. Gadi Praveen Kumar, Learned Deputy Solicitor General of India, Mr. Pratap Reddy, Learned Public Prosecutor, Learned Senior Advocates, Learned Members of the Bar, Registrar General and her team of Registrars of the High Court, Director Judicial Academy, Member Secretary, Telangana State Legal Services Authority, Secretary, High Court Legal Aid Committee, officers and staff members of the High Court, my friends from the press and media, my family members, ladies and gentlemen. Namaskaram. A very good afternoon to all of you. Brother Justice Navin Rao and Learned Advocate General Mr. Prasad have spoken very generously about me. I do not know whether I really deserve such accolades. However, I accept the same as parting compliments and blessings with all the humility at my command. Friends, it is customary to end a farewell reference speech by acknowledging the assistance of the officials and the staff. However, I would like to make a departure and instead start my speech by acknowledging the wonderful assistance rendered to me by my staff. When I came here as a preemie judge in October 2021 and was holding court in the second court, Mr. K.V. Suryanarayana was my personal secretary. He and his team rendered yeoman service to me during my stint as a senior judge of this court, even during the summer vacation of 2022 when I had to stay back here. I acknowledge the able assistance rendered by court officers P. Ramakrishna and C.H. Rajendra Kumar, who continued their journey with me from the second court to the first court. I would be failing in my duty if I do not acknowledge the excellent assistance rendered by courtmasters Srimati L. Usharani, Srimati V. Saritha, Srimati K. Lalita, Mr. M. Raghuram, and Mr. A. Jitendra Reddy. I also express my gratitude to Ms. B. Anusha, law clerk, for her able assistance and research backup. I am indeed indebted to my chamber attender, Mr. N. Narasimha, who was with me like a shadow and stayed back despite his promotion as assistant. He and his colleagues made it so comfortable for me, both in my chamber and in court. I also express my deep sense of gratitude to my personal staff at home, including the personal security officers, Mr. M. Ramakrishna Reddy and Mohammad Zahibuddin Siddiqui, as well as the entire security team, both in my residence and in court, and the chauffeurs. Recently, I had attended the conference of Telangana State Judicial Employees Association, where I had spoken about the importance of all the stakeholders in the justice delivery system. According to me, there are four important stakeholders. First and foremost is the litigant. Second, and not necessarily in that order, is the lawyer. Then we have the court staff, and finally the judge. Unless there is mutual respect by each of the stakeholders towards each other, the system will not be able to perform to its optimum and justice will be the casualty. We must always keep in mind that we are all here because of the litigant public. Most litigants, barring a mischievous few, we have quite a few in Hyderabad, come to the court or approach the court as the last resort. They come to the court in a state of helplessness or despair. It is our duty to ensure that they are treated with respect and dignity and their voices are heard. A litigant has the right to know within how much time his case will be decided. The system must be in a position to address this issue. The answer need not be with any mathematical precision, but nonetheless, it is the legitimate expectation of every litigant that his case will be heard fairly and decided within a reasonable period. As we often say, what is reasonable would be dependent on the facts and circumstances contemporaneously prevalent. Lawyers are not only the spokesperson of their clients, but they are also officers of the court. Advocacy is a noble profession. I need not restate the stellar role played by lawyers in contemporary world history and in our freedom struggle, including in the framing of our Constitution. I always maintain that bar and bench are the two wheels of the same chariot. Together they constitute the justice system. The bench is an offshoot of the bar. Neither the bench alone nor the bar by itself can secure justice through the people. I am of the firm opinion that there should always be a meaningful and continuous dialogue between the bar and the bench on issues related concerning administration of justice. I am reminded of what Justice Rajamannar, the first Indian Chief Justice of Madras High Court, who served for 13 long years, had said. The High Court, in the larger sense, is not merely a collection of judges. It is an institution of which the bench and the bar, and I would add the public, are all integral parts with its own traditions and ideals which have inspired them and standards which have been maintained. While the lawyers should be respectful towards the judges and show due deference to the court proceedings, judges should also treat the lawyers with respect and dignity. For a judge, trust and confidence of the bar is his greatest asset. It is unquestionably true that courtesy breeds courtesy, and that courtesy must begin with the judge. While the law is well settled regarding conduct of lawyers vis-a-vis the court, it is essential, however, to emphasize courteousness of a judge towards members of the legal profession. What transpires in court is nothing but a dialogue and debate. In such dialogue and debate, civility and occasionally humor are essential. By its very nature, court proceedings cannot be uncivil. Civility is a must in court. It ill behoves anybody, be him a lawyer or a judge, to shout and scream in court. The greatest asset of a judge is the trust and confidence of the bar. It must always be remembered that respect can never be demanded. It has to be earned by your conduct and performance. The road to dignity is humility. There is no place for arrogance in the world of justice. Friends, while judges decide cases argued by lawyers, in the ultimate analysis, it is the lawyers or collectively the bar who are the judge of judges. I believe instead of focusing entirely on the judge as the final arbiter or decision maker, the focus should be on the court, of which the staff are an important segment or stakeholder. They make the wheel of justice complete. The role played by the staff in the administration of justice cannot be overlooked or underestimated. It is therefore equally important for a judge, being the presiding officer of the court, to treat his staff with respect and dignity. Public perception of a judge, or for that matter the court, is very important. As Justice Frankfurter of the United States had famously said, judiciary has neither the purse nor the sword. It has only the moral authority, which is based on public confidence. Chief Justice Marshall of the United States Supreme Court had said, we must never forget that the only real source of power we as judges can tap is the respect of the people. It is undeniable that the courts are acting for the people who have reposed confidence in them. Chief Justice Murray Gleeson of the High Court of Australia had said, confidence in the judiciary does not require a belief that all judicial decisions are wise or all judicial behavior impeccable. However, what it requires is a satisfaction that the justice system is based upon values of independence, impartiality, integrity, and professionalism. And within the limits of ordinary human frailty, the system pursues those values faithfully. Courts and judges have a primary responsibility to conduct themselves in a manner that fosters that satisfaction. That is why judges place much emphasis upon maintaining both the reality and the appearance of independence and impartiality. Therefore, it is important to always remember that justice must not only be done, but must be seen to have been done. A judge has to be not only impartial, but must be seen to be impartial. As Lord Denning had said, justice is rooted in confidence, and confidence is destroyed when the right-minded go away thinking that he was not heard or that the judge was biased. Therefore, in each and every case, it is the judge who is on trial. He has to ensure that he does his job honestly and properly. As observed by Lord Atkin, justice is not a cloistered virtue, and she must be allowed to suffer the criticism and respectful, though outspoken comments of ordinary men. I became a lawyer in March 1991. At that time, I had wondered whether anybody would come to me to seek my professional assistance. Soon after I had joined the bar, my father was appointed as Advocate General for the state of Assam for the second time. On principle, I did not join his official team and charted out my own path. My career as a lawyer progressed with lot of ups and downs, and in due course of time, I was designated as a senior counsel. Then again, I wondered whether I would be able to perform the onerous responsibility of being a senior counsel. Initially appointed as Junior Standing Counsel of the Income Tax Department, I was subsequently appointed as Senior Standing Counsel. For long 16 years, I was associated with the Income Tax Department. It was a great learning experience for me. During this period, I also represented the state of Meghalaya and the state of Arunachal Pradesh, as well as appointed as Standing Counsel of the High Court. Towards the end of my professional career, I was appointed as Additional Advocate General for the state of Assam. But friends, I must make a confession that basically I was a petitioner's lawyer, though by virtue of the above assignments, I had to represent the respondents many a time. It was always a challenge, and it gave me immense pleasure to build up a case, to develop a legal point and argue with passion before a difficult judge and obtain a favorable decision. Therefore, I am aware how difficult it is to build up a case on behalf of the petitioner or the appellant, and overall to sustain in the profession as a counsel for the petitioner or, for that matter, the appellant. As Chief Justice UL Bhatt used to say, if it is a borderline case, he would always tilt in favor of the lawyer or the petitioner. I took oath as a judge of the Guwahati High Court on October 17, 2011. Then again I wondered whether I would make a good judge. On the eve of my elevation, I had received a letter from Justice B.P. Saraf, who was a friend of my father. Justice Saraf was a judge of the Guwahati High Court and then Bombay High Court, and finally served and retired as Chief Justice of Jammu and Kashmir High Court. He wrote, "Most litigants approach the courts in distress. Never be a negative judge." I have preserved this letter jealously, and these profound words had a deep and lasting impact on me. During the early days of my judgeship, I used to read the briefs very seriously at home. One particular matter I thought deserved dismissal, and I had marked it accordingly. On the next day, learned counsel for the petitioner Nishitendu Chaudhary argued the matter in such a convincing manner that I not only issued notice but also ended up granting an interim stay. This was an eye-opener for me and an indelible lesson learned right at the threshold of my career as a judge. First and foremost, while one should go through the case papers before coming to court, one should not read it in such a manner that you make up your mind. Secondly, and it evolves from the first point, a judge must always have an open mind. Thirdly, I realized the importance and effectiveness of oral hearing. While written submissions are no doubt very useful, I am of the considered opinion that those cannot be a substitute for oral arguments. After almost 8 years of judgeship in Guwahati, I was transferred to the Bombay High Court, and after a successful 2 year stint in Mumbai, I came to this court on transfer in October 2021, and in due course, I was elevated as Chief Justice. My distinguished colleagues here, including those who are no longer on the bench, members of the bar and the registry, have embraced me and my family with open arms. From day one, I have never felt that I am an outsider. My attachment to this place and to the High Court has only increased with the passage of time. As I had disclosed on an earlier occasion, whenever I used to come back to Hyderabad from any other place, I felt as if I was coming home. Each one of my brothers and sisters are special. Each one of you have made our stay in Hyderabad so comfortable and memorable. We will carry fond memories of our stay here and cherish them forever. But friends, nobody is permanent, whether in life or in law. We are all transient except the institution. Therefore, it is the institutional interest alone which must be the sole consideration, nothing else. From the far east to the extreme west, then to the south, it has been a roller coaster ride for me. And now from the south, with the blessings of Lord Balaji, I am on my journey to the north. I have no regrets. However, before parting, I can only say that there is no full stop in law, as law and courts are always evolving. We as lawyers, as judges, and as human beings are all evolving. We are always evolving. In that context, I would say every case is a new case. There is no big case or there is no small case. No roster is less important. Every day is a new beginning. Just like there is no perfect human being, a perfect judge is yet to be born. A perfect judgment is yet to be delivered. I believe that perfection is nothing but a mirage. Chasing perfection is like chasing a mirage. There is no and there cannot be any perfection in life and in law. I am extremely happy that destiny had brought me to this esteemed institution and that I could be a part of the recorded history of this glorious High Court as well as the judiciary in the state of Telangana. My sincere thanks to all my distinguished colleagues, including those sister and brother judges who partnered me in the division bench. But for their invaluable assistance and contribution, many of my judgments would have remained inconclusive. I thank them from the bottom of my heart. Registrar General Srimati K. Sujana is a very capable and competent officer. She and her entire team in the registry, including all the registrars, made my task that much more easier and comfortable. I would like to place on record my appreciation for the sincere and commendable work rendered by each one of the registrars and each member of the registry. My thanks to the director, faculty and staff of the Telangana State Judicial Academy. I would also place on record my appreciation of the excellent work undertaken by the member secretary, officials and staff of the Telangana State Legal Services Authority. The protocol staff and the medical staff of the High Court have rendered commendable assistance to me, my family and my guests. I thank each one of them for their tireless service even at the oddest of hour. My sincere thanks to Mr. Ali Muhammad Sarfaraz, Principal Secretary, Mr. T. Nagesh Babu, Principal Private Secretary, Mr. P. L. Narasimha Rao, Private Secretary, and Mr. G.B. Shastri, Personal Secretary, and the entire staff of my secretariat for their commendable assistance. On the eve of my new journey, I fondly remember and pay homage to the memory of my late father, Suchendranath Bhuyan, and my mother, late Subhadra Bhuyan, who incidentally had solemnized their marriage on January 26, 1950, the day our constitution came into effect. My wife Sanghamitra and my daughter Shweta are my pillars of strength. They are my advisors too. It is their sound advice which has kept me on the right track. Sometimes I go here and there, but their advice once again brings me on my track. Finally, my friends at the bar, I have no hesitation in saying that it is a very good bar, and I have benefited so much from the deliberations in court. I can confidently say that this bar is second to none. As a judge and Chief Justice of this court for slightly less than 2 years, I may have used harsh words against some of you while in court. I can tell you these were never intentional. However, if I have hurt the sentiments of anybody, my sincere apologies for the same. Before I leave, I can assure all my friends, both at the bar and on the bench, that I will stay connected to this High Court. And whenever you visit Delhi, please feel free to call on me, and I will be more than happy to welcome you. I can also assure that I am also sure that as and when I come here, my friends at the bar will offer me a cup of coffee or a cup of tea, as I must confess, I am very fond of my cup of tea, including the Irani chai. Thank you very much and God bless. Thank you.